Okay, so uh, obviously this week's been a busy week for everybody. We've had the assignment due this week, and one of the significant things I thought that came out of the assignment was the fact that there was a great amount of communications. I saw obviously a lot of communications to and from me about specific things, and communications between everybody on the website, and I thought that was very positive for us all as a class, in the sense that it caused interaction. It caused us to think about statutory interpretation, and I think as a group, from a group perspective, that was very positive. I've started. I'm old school in the sense that I've been printing out the assignments, and I've been working my way through just printing them all out, obviously, and I'll be trying to turn those around as efficiently as possible and get them back to you in due course. But thank you for all your efforts in that regard. This week's lecture really develops on from where we've gone before. That is, we're developing some of these concepts, and we're focusing on this idea of purpose and intention. What we're really looking at is, how do we interpret specific sections by reference to what Parliament may or may not have meant when they passed those sections? And is it the case that over time, the interpretation that the judiciary can place in a specific section, is it the case that that interpretation can change? We consider some of the techniques, obviously, that courts use in this regard, and how they might either narrow the meaning of words or expand the meaning of words. And I think a good example of this, which is quite a well-known example, is that our Commonwealth Constitution doesn't really mention this concept of freedom of speech. But over time, the High Court have interpreted the Constitution in a broad way, an expansionary way, to say, well, look, it's not mentioned specifically there, but there is an underlying concept in our Constitution that there is a freedom of speech. So that, I think, is a good example of how interpretation can change, how it can be a little bit dynamic, which are these words that are mentioned here. So there are some key terms, obviously, that we focus upon. Ambulatory interpretation is this idea that legislation can be dynamic, that a 1904 Act, and I'm just making that up, might have a very different interpretation in 1930 to the interpretation that might be applied today, even though the words in that section or in that act haven't changed. There's also this idea of equitable interpretation, that there might be an underlying reason, they use the word spirit there, but an underlying fairness, which obviously is another way of describing equity, an underlying fairness which is universal, it's broad in its application, and that's the basis for how we should, or how the judiciary and how we should, as practitioners, interpret the legislation. The purpose or ultimate aim in the legislation is what Parliament, as the sovereign parliamentary sovereignty, as the sovereign entity within the three arms of government, what they are meaning to achieve when they enact specific legislation. To read down legislation is to read it narrowly, to limit its meaning, to look very much to the words and to focus on those words in a way that narrows the meaning. Whereas to read in is to find words or meaning that aren't actually included in the provision. So that example I think of the Constitution is a good one. The words about freedom of speech aren't anywhere specifically in the Australian Constitution. But the High Court has said, well, they're really in the Constitution, even though they're not in. They've stretched the words of the Constitution and the meaning to give effect to what they viewed as being the underlying purpose of the drafters. To strain the legislation is to do what we were just talking about, that is to read it in, but to read it in a way to give effect to something which isn't necessarily expressly stated in the statute. Okay, so the first of these concepts is this idea of intention. And you see they start off here with just an Oxford Dictionary reference. The thing intended, the object or the ultimate aim. I think the object is a good way of describing it. And it's a good way, I think, because if you look at most acts now, certainly in Queensland, they often will have an objects clause, an overarching thing. This act is there to provide for X, Y, and Z. It sort of sets a parameter, it sets a theme, and really what it's setting is an intention. It's Parliament saying, why did we pass this legislation? What is it intended to achieve? And obviously that helps us in defining what the meaning of specific sections in it are. I've often used the example of the tax legislation. The tax assessment acts are there to achieve revenue for the Commonwealth by virtue of the assessment of tax. And so the underlying intention is to gain revenue. And so when you put it in that context, the interpretation that favours the tax officer's position will often be the one that's favoured. The textbook writers talk about purpose, and they say, why are we doing something? That will help us to define the purpose and who is that directed towards. And obviously the example here was the example of cigarette advertising. To stop people from smoking, or to stop people from continuing to smoke, or to stop them from starting smoking, is the overarching object. So an intention that meets that object will be the intention that is favoured. So you can see it will be, and it has been, challenging for the cigarette companies to have provisions in these acts interpreted in a way that might favour them, because this overarching object. And that's just the example used here.
Before we continue, can I ask a question?
Of course.
Okay, I'm having trouble trying to differentiate between the purpose and the intention. Which one has a broader meaning?
Well, I think there's a lot of similarity between the two. We're focusing here on intention, but it's or the word intention, but they're really very similar. The purpose of the act is defined, you might remember from last week, the definition of purpose is actually defined to include the object. So in fact, it's mentioning here this week under the heading object, under the heading intention, the object as well. So in fact, I think they're very, very similar. I don't think you can distinguish the two. And in fact, that's what they're doing here. I don't think you can say purpose is broader or narrower than object or intention. I think they're blended as one. Does that help in any way? I haven't answered your question in the sense that I don't think the two of them can be distinguished.
So they're the same. I mean, when they talk about intention and then they talk about purpose, because I thought that especially when they give the example of that the object is to improve public health, but the intention is to stop people from smoking. I thought that maybe the intention has a now effect,
A practical effect.
purpose has a bit of futuristic aim to it.
Well, I think if you have to break them up, you do it in the reverse. You'd say the intention is to, let's say, have an impact upon the outcome of, let's use the cigarette example, have an impact upon the number of people in society that are smoking and or will start smoking. The purpose, though, might be to have a direct impact upon advertising and packaging and the practicality. So the purpose is more now and the intention is more in the future. But I don't think, I think we're creating those breakups. I don't think there's actually a clear, I haven't seen any a judge saying, well, that's what you should do. You should distinguish between purpose and intention. I think what the judges are looking for is what's Parliament said about it? What have the lawmakers, the legislature said about these provisions, and how do we draw that into our interpretation of them?
Donnie, my interpretation of this is that they need to be really read and considered together, since one almost does lead on to the other, and you can't see them in isolation.
Yeah, I think that's exactly right. So that if you distinguish between the two of them, you're creating some false breakups, and I don't think it's intended to do that. Exactly, John.
Okay, so why do we have two distinct chapters in the book, one for intention, one for purpose? Why didn't they just mention that they are fairly similar and have like one chapter for them? That's why I try to differentiate between the two, because there's two distinct chapters. And
no, I agree. I agree with you. In fact, I think this whole course could be now summed up in the purpose section in the Acts Interpretation Act. That in a lot of ways we're breaking up one section in an act into 12 weeks of learning, because I don't think there's a great differentiation. I agree with you that to some extent it feels like we're over a number of weeks actually repeating specific concepts and breaking them up and cutting them up into little tiny pieces, but in fact we're just learning the same thing if you think about it, because we've focused on, last week we were focusing on the objects section as well, and my recollection is we were looking at similar concepts the week before. We're looking at things from a different angle and we're examining them in a different way, but we're not necessarily, there's some false examination in the sense that we're looking at them from a different perspective. Purpose, intention, fundamentally they're very similar, but obviously they have different chapters, as you say in the textbook. It's a bit like the whole of, it's why we have lawyers, because if everybody could see exactly the same answer to something, there'd be no legal profession. And although they don't want to tell you that, if you go to one judge, you get one answer, and you go to another judge, you might actually get a completely different answer to exactly the same question.
Yeah.
But of course, we don't talk about that. It's best not to talk about that.
Yes, all right.
I hear what you're saying very loudly, in the sense that it does feel as though we're looking at the same things, calling it a different thing, but we're looking at it in the same way.
Okay.
All right, so the purpose, obviously they say the purpose of the cigarette advertising is to improve public health. The intention is to limit the exposure of the public to cigarette advertising. I mean, even those two sentences, which is a good example of what you were just saying, they read it's just a paraphrase of the same thing in a lot of ways. They're not distinguishing them the way, say, we were, which is a long-term view and a short-term view. But I think here the key is the purpose flows on to why we are doing something and who is it directed towards. So and this is a classic academic breakup of something which is not necessarily a judicial approach. That is, I don't think you'll find a judge articulating a stepping stone approach like this. You might, but the tendency would be for a judge just to ask the first question and then to look for something that is tangible, so a second reading speech, an explanatory memoranda, etc., that articulates the first question. Whereas the academic approach is to say the purpose, why, and then to ask that's really a factual question. Why then are we doing something, and who is it directed towards? The intention, what are we doing, and how are we doing it? So that's to break it up in a, and Carla, this is relating to your question. They're saying, well, you break it up in the sense of, and I would do it around exactly the opposite way to the way they've done it here. So they're saying this one is about the future, and this one is about the practical, whereas I think it's around the other way. When I hear the word intention, I think about the future. My intention is that I want to grow old. The purpose is, how am I going to achieve that? Well, I'm going to eat better, I'm going to sleep better, I'm going to do exercise. So in fact, I would reverse completely the way our textbook writer has done it.
Well, that's funny you should say that, because when I read the chapter, I thought the same thing, and then I read the notes and they're reversed, and then I went to the Oxford Dictionary and they're reversed, and then I did a bit of research and they're also reversed from what I would think. I think they gave the example of someone that was studying, that his intention he was studying and his intention was to pass the exams, but his purpose is to get a better job. So they said that the purpose gives more of a futuristic approach, and the intention says something about the now, or the way that the things that we do to achieve the now.
I mean,
I think I asked the question.
I think the key thing is that when they're mentioning purpose and intention, they're always drawing back to objects. And when in the section 15AA of the Commonwealth Acts Interpretation Act, from recollection, it mentions purpose and object as one.
Yes.
And the Queensland one does it as well. And I can't recall whether the word intention is in there as well, but they're blending them.
I didn't find it. I did. I looked at the 14, the 14A. It's not there, and I looked at from the Acts Interpretation Acts, and it's the analogy to that is the Vienna Convention of Treaties, and I looked in it as well, and there's no mention of intention in it as well. So, that's why I'm asking the question: is there any difference between the two? Should we as lawyers make a difference between the two words?
As a practitioner, I don't think so.
Yeah.
As an academic person reading through these notes, they do. So I mean, it's a good point you raise. It's a good point you raise. I'll go on, and I think let's come back to that in due course.
Okay.
I'm
sorry. I keep putting mute, but because I don't want my daughter to scream and interrupt the session, so I'm going to mute the audio.
Thank you. So in here they mention a 2011 case. It's a good example. It's a High Court case from 2011. You might recall it involved the question about the Migration Act. At the time, there was this whole issue of what was the Commonwealth allowed to do legally at that time in terms of persons who were arriving or coming to Australia, particularly by boat, and there was the interpretation by the High Court of this phrase, to any country, which is mentioned in the Migration Act 1958. That act, of course, it's a 1958 act, but it's been changed many times since. It had some significant changes made to it in that post 2001 period after September 11 and after the Tampa incident, if you remember that, which was both of those things occurred from recollection in August-September 2001 from recollection. But that phrase was interpreted by the High Court in 2011, and it was because there was a question regarding where individual persons could be sent to by the High Court. Did they have to go to a country which abided by the different refugee conventions? So if Australia was sending people who arrived in Australia, let's say to PNG or to Malaysia or to somewhere else, did those people have to be sent to a country which itself abided by the refugee conventions? And the High Court read that phrase, to any country, in a way so as to facilitate or to give effect to Australia's signatory to a range of refugee conventions or conventions. And obviously there was a lot going on in the background politically and while this case was being determined. So Parliament had obviously expressed their view because they were the ones through the executive who were doing these things. So the High Court, or the judiciary, being the High Court, were having to reinterpret what the executive and what Parliament were saying and doing. And the judges made some strong or significant statements. Justice McHugh and Chief Justice Gleeson talk about the search for intention being a legal fiction. And I think that actually relates to what we were talking about, and that relates to your question from before, Carla and John, that you were mentioning, in the sense that there's two of the Chief Justice of Australia and probably the second most senior judge at that time, saying this whole idea of intention is fictional. It's not real. It's an academic process rather than a practical or practitioner process or judicial process, in the sense that there is no such thing as an intention. You just read the words in the statute and you might have an object clause in the statute. You might have an articulation of a purpose, but trying to find something beyond the purpose is false. It's fictional. Chief Justice Gleeson said, the search for the intention of Parliament is necessary. It might be fictional, but it might be necessary because the constitutional relationship between the legislature because of this relationship between the legislature and the judiciary. The legislator is the primary lawmaker and not the judiciary. So once you've worked out what they're saying, then you must enforce what they're saying. But that phrase, that para there seems to contradict what's being set up here, or that whole concept. But this has to be correct. Parliament is sovereign. Parliament sets down the laws. The only thing that judges are supposed to do is to interpret the laws. And obviously in Queensland we've had a bit of toing and froing between the judiciary and the legislature in this regard recently. The legislature has set some parameters or has put down some statutory provisions, and it's not up to, or the question is whether it's up to or not up to judges to apply those provisions, even if they think, regardless of whether they think they're good or bad. So when it uses the will of Parliament, to some extent that's like a fourth definition. We've been talking about purpose, intention, objects, the will, or maybe that's the same again. Maybe we're just repeating the concept. When textbook writers in the courts talk about the will of Parliament, what are they talking about? Are they speaking subjectively, which means are they trying to work into the mind of the individuals who passed the legislation? And it says here, your textbook refers to intention as a metaphor for describing the intention revealed through an examination of the statute in the light of the context and the purpose. I.e., that's it doing it again, that intention and purpose effectively are the same thing. The courts don't determine what Parliament intended to say, they work out what Parliament was saying by obviously examining these things. And they're just giving some examples from page 73. But I agree. I think this to some extent we're looking at the same issue from a different angle. This section here, the courts can obviously look at the meaning of a specific section or sections by having regard to a third-party reading. What they're saying is the court is sitting away from the position of the parties. The parties themselves obviously are subjective. They say they will favour intention that favours each individual party, and then the court, like a referee, looks at the section and says, well, what does this actually mean? But the last sentence is telling, because what it says is intention must be determined by reference to the document itself. So in a lot of ways, that's saying look at the literal meaning of the words. Look at the sections themselves. Don't try and draw upon all this extra statutory material. It feels like we're going round and round in circles because the way the textbook is dealing with this is to effectively repeat what's said in the past chapters. If there is no parliamentary intent or intention, what do we do then? Or if we can't easily identify or effectively identify the intention? And they mention here a High Court case from 1990, Mills and Meeking, volume 169 of the Commonwealth Law Reports 214. This was a case where the words of the original trial judge, in the words of the original trial judge, the defendant drink driver was charged under the wrong provision in what was then the Victorian Road Safety Act. And it talked about taking breath samples. You can see why some of these cases might have been run because people were going to lose their licence, so they keep appealing up through the system. And what happened, Justice Dawson, who was a Victorian judge, he said, Lord Diplock pointed out in Jones and Rotham Park Estates, which is a English case, the task on which a court of justice is engaged remains one of construction. Even where that involves reading into the act words which aren't expressly included. So a broad reading. Find the meaning sometimes by adding words yourself, words that may not be there, implying the words into the statute. You can do that if three conditions are fulfilled, he said. First, the court must know from reading the act as a whole precisely what the mischief, and that's another way of saying the object, was that it was the purpose of the legislation or remedy. Second, what the court has to be satisfied that by inadvertence, Parliament has overlooked an eventuality which must be dealt with. And third, the court must be able to state with certainty what words Parliament would have used to overcome the omission. That's not an easy process to get through So what Lord Diplock was saying is, if you make it past this hurdle, and the next hurdle, and the third hurdle, then you can add words as the judge into a section to create a meaning. But you can only do that if you can cross those three hurdles. Now, and obviously what's happening here is that one of the Australian High Court judges is taking this process and applying it in Australia, or applying it in this case in the Australian context. And he says, and this is what Justice Dawson says, he says, I have no trouble in coming to the conclusion that the first two conditions up here have been fulfilled in that case, so in as to the Road Safety Act. But the third condition creates more difficulty. And he's comparing a couple of subsections. I think that if the defect has been pointed out to Parliament, it would have added the words motor vehicle. And he's commenting about whether those words should be added in. And we don't get the conclusion there, but we're seeing that he was troubled by whether he should or shouldn't imply that those words were in there. Add them in himself. And you can see his great hesitancy in that paragraph in going through that process. But once again, this is one judge, admittedly a High Court judge, but one judge going through this process, and a different judge might take a different view on that. Here they talk about interpretive techniques, and the court needs to consider whether the interpretation of a specific legislation is straining the natural or usual interpretation of the words. In fact, what's going on here is exactly that. It's straining the words that are really there. The words that are really there don't include motor vehicle in that sub-paragraph, in that section of that act. And the question is, should those words, should that section be strained to add those words in, or should it just be read what is there? Reading down, if you read judgments by a judge like Chief Justice Barwick, Sir Garfield Barwick, who was Chief Justice of the High Court of Australia from 1964 to 1981, if you read his judgments, they're short. And when he interpreted legislation, generally, you could say he was reading the legislation down. He wasn't a judge who was implying words into sections and trying to look to all this extra statutory material. His focus was to read what was there. What does it mean? When I apply that to the facts, what's the outcome legally? He was a judge who tended to read down, and often they'll call that type of judge a black letter lawyer, someone who focuses on the words. And I think it's fair to say that Chief Justice Gleeson generally was that type of lawyer as well. Shorter judgments, or relatively shorter judgments, focused on the plain meaning of the words, and who, it could be said, tended to read down the meaning of things rather than to expand them. And you can see when that word or that phrase we were looking at up here, legal fiction, was used by Chief Justice Gleeson and Justice McHugh, I should say. That phrase, I think, is indicative of this concept of reading down, that he wasn't so interested in working out Parliament's intention or working out what all these other things meant. He's focusing on the act in question and the meaning of the words. And they give a number of examples here. That's an English Queen's Bench Division case. New South Wales law case, New South Wales law reports of this concept of reading down. But the first is to make, they're looking here at, there could be two different types of inadvertence. I mean, what they're talking about there is that the focus of the act. What is the focus of the act? And just to focus on the words and to focus on the meaning that comes out of those words and maybe other sections in the act, not to add words in. The first is to make no provision whatsoever for a particular problem, and the defect cannot be cured, so you can't add words in. The second is to address the particular problem, but fail to provide in the act appropriate words to give effect to what needs to be done to correct the problem. The court can remedy this omission, I'm pretty sure there's only one M in omission, through the process of construction. So construction, i.e. reading what is there. And they refer to the Commonwealth bikie control legislation, which went to the High Court in 2011. Sorry, not the Commonwealth, the case which went to the High Court in 2011 as the bikie control legislation. And they were looking there about, that's Wanahu, which is 2011 High Court of Australia 24. So this, by the way, you will already know potentially that this type of referencing here, that's the internet reference that goes on, as opposed to this one, which is the authorised report, the sort of the formal printed bound report, which themselves are published on the internet, but they're authorised in the sense that they're properly published, checked in a formal sense, whereas this one's just the internet publication of the report, or of the case, I should say. All right. Reading in, so we've just been focusing on reading down, so reading narrowly, reading in, exactly the opposite, reading broadly, adding additional words in order to give effect to the purpose. And they're talking once again about this strained construction, this idea that we're trying to, or that the judiciary are trying to focus or to add words or to read up or extend the meaning of the words to take into account specific circumstances and ensure that the words match the intention or the purpose rather than just ignoring that and focusing upon what's actually there. You can see a lot of this is related to the drafting of the specific sections. If the drafting is well done, there won't be a disconnect between, there won't be a need to read down or up. There won't be a need to interpret to such an extent because it'll pick up the scenario without, it'll be so clear, so plain and literal from the meaning of the words in the sections themselves. And that's what they're saying here. What I just said is what they're saying here. Where the purpose of the provision is clear, the court may be justified in giving the provision, it should say a strange construction to achieve the purpose, provided that the construction is neither unreasonable nor unnatural. Read the section or the provision as if the words were there, even though they're not there. The court can identify the mischief that the statute was focusing upon. It can look, it can work on the assumption that even though Parliament drafted and passed a specific section and a specific act in that form, they really meant, had they had the opportunity to consider it, they really meant to add those words into that section to pick up this scenario. That's what they wanted to do. They just, it's almost like they're saying there's a typographical error, or that no one could possibly draft the section to pick up all the circumstances they wanted to consider. I mean, I think and this is what the textbook's saying, is that such an approach can actually offend the doctrine of the separation of powers. Because what have you got? You've got another legislature. But then people will say to you, well, every time a judge gives a decision, they're making law, and so why does it make any difference when they're making law by adding some meaning into sections, particularly where that meaning is reflecting what the intention was? But then the contrary argument is you can never work out the intention. It's not clear to you. All you're doing is interpreting the intention as well as interpreting the section or sections.
Can I just interrupt?
Of course.
I have to go. Thank you so much. I'll have to watch the rest of it later, but thank you so much.
No worries. Thank you very much. Ambulatory or dynamic interpretation. This is this idea that, we first looked at this phrase, ambulatory interpretation, when we were trying to work out whether an earlier piece of legislation, which was referred to in a later act, whether you looked at, so if this new act referred to another act, do you look at that act at a specific point in time, or do you look at that act as it's changing over time? But the other meaning of ambulatory or dynamic interpretation is what we mentioned earlier in this lecture, which is, or in this part, in the sense that the circumstances of society mean that we read sections in a different way. There are some very good examples of this. For example, the idea that when the Constitution, the Commonwealth Constitution, was passed, not all Australians in a legal sense were given the same rights. Maybe in an electoral sense, not all people necessarily had the right to vote. And over time, there's been a change in the meaning of specific words and sections, where the idea that people shall be equal at law has been read into statutory provisions to ensure that that is the case. And they focus upon, you could say that's a dynamic interpretation, that in the sense that it's the same sections are there, but over time they're being read in a different way. Statutes can have a long lifespan, and so of course society changes. For example, when the internet came in, many of the statutes had not had to deal with the fact that things on the internet are so completely different from how they may have been before the internet. And so judges have had to read, well, does this provision, if I have regard to the facts relating to the internet, does this provision have impact upon the internet? And of course, the provision was drafted before the internet was even invented, so there can be no question as to the dynamic nature of that interpretation there. Significantly, in Queensland, we have section 14 capital H, which says, in an act, a reference to a law includes a reference to the following: the law as originally made and as it is amended from time to time since it was originally made. Sometimes I think one of the hard things with this section is that acts are amended, but sometimes acts are repealed. A new act is put into place, but it deals with the same factual circumstances or the same purpose. And I think that's where sometimes it hasn't been clear or it requires a careful check to see, well, is it a new act or is it just an amendment of the old act? And is it an amendment which just changes the name of the old act? And so sometimes you can find sections. I had cause to look at this section just the other day because I was looking at an act called the Church Entities Act 1861 or something was words to that effect. And then there's a new act which I think is like the 1994 Church Entities Act. And it refers to land and church bodies and things like this. And it was a careful set of checks to make sure this section wasn't applicable or may have been applicable. And so some of those things cannot be that easy, sometimes aren't that easy to answer. So there's an example there, and it just mentions a New South Wales Court of Appeal decision, but I won't focus on that. Let's move on to equitable interpretation. This is this idea that underlying statutes, behind statutes, there's a real jurisprudence of what is fair, that you in fact interpret some statutes by reference to fairness. And I think, of course, that's going to be a part of any interpretation process. If it is an interpretation which leads to complete and utter unfairness, inequity, then a lot of people would say that's completely contrary to the spirit of Parliament or the spirit of the legislature. We've already been speaking about dynamic interpretation, or we were talking about dynamic interpretation up here. This one down here is slightly different because what it's saying is that the dynamic interpretation can take into account potentially social values and political policy, the broader context. And I think when you look at some of those cases like that immigration case we were looking at earlier, some of those cases do take into account that there are broader social things going on and broader political things going on. Particularly at the High Court level, a lot of the case law at that level takes into account some of those things. So there's
basically it's saying that the law is not static.
Sorry, John, can you say that again?
I said, so it's basically saying that the law is not static, it evolves.
Exactly. I mean, I think you read something from a judge like Barwick. He says the law as to a statute basically never changes. The law is the same. The interpretation of those provisions fundamentally will always be the same. Judges don't make law. You talk to you read the writings of other judges after they finish on the bench, and they will say, no, the law is an ever evolving. It's a creek line that continually ebbs and flows. It changes over time. It's moving. It's dynamic. It's creative. Judges make law, etc. So you've got these two extraordinary ends of the spectrum, and this dynamic interpretation approach is taking into account that. It's saying that the law is evolving, that there's an ever changing ebb and flow of different things that might impact upon interpretation. Obviously, this is as we were saying before, I think this is an academic process of trying to look at things in a different way, to identify what a judge is actually doing and how do we do it in a practical sense, and what are some of the things they might be using. I don't think you're going to read a judgment and find a judge saying, I used an ambulatory construction, I used a dynamic interpretation. What you'll find is that judges are applying facts to specific laws, and then in an academic sense, we're reading what they're doing and we're seeing these things occurring, and we're trying to give them a description. How did they do that? Well, they did it by virtue of using a dynamic interpretive approach, or they used an ambulatory construction, or they used an underlying fairness test in the way they applied all of these things together and came out with an answer. What we're seeing is that there are different ways of approaching interpretation. That it's not it's not always just based on the meaning of the words in a section. It's based upon what parliaments have done or what the legislature have done in an overall sense, how they've, and we can't override what they've done, what Parliament's done. There must be an open answer somewhere, but we need to focus on their intentions. And when they talk about the two approaches, the pragmatic and the formal, pragmatic is I'm going to read things in, I'm going to interpret it in the way that I think they wanted to write it rather than the way it has been written. Formalist would be the Barwick approach. I'm going to read what's there, I'm going to focus on what's there. If it's not there, I'm not adding words in. It's not my job to add words in. I'm going to be very strict. I'm going to read down sections rather than reading them out. All right. I mean, at different points in time, the topic obviously talks about purpose and intention, but in a lot of ways it's talking about the same thing, and it's looking at the same thing from different ways, as we've said. I think the best way to describe this topic, though, is to focus on these words, pragmatic or formalist. That is to say, are we going to expand it or are we going to narrow it? Are we going to be expansive in the way we interpret, or are we going to be limited and focused and literal, and are we going to apply the plain English reading of things? All right. Just don't go anywhere.